Yes, thank you very much. So yes, my name is Vink, and I'm the in 2022 president of the International Trademark Association. And I would like to thank the IPKey Southeast Asia for this opportunity to address the important topic of bad faith trademark registrations, which is the topic we're going to talk about. So you may know Inta, which is a global brand owners organization, and we have been targeting this bad faith issue over a long period of time because we consider it very important. So I will be making some introductions on INTA. I will provide an example of the company I work for. I will explain that later, and then we will also hear the stories of Joel Blank and Petra Hercule also on this matter. So let me start by sharing my screen. So briefly on the INTA in Southeast Asia, we have been working together with the group from the 90s actually, and we have also been conducting bilateral work with all 10 IP offices that consisted of providing feedback on trademarks and other IP rights in the Southeast Asian countries. We have established as an organization an office, a representative office in Singapore that covers the whole region. That was in 2016. And whenever you have any questions about INTA or this particular activity of the office, you can always contact Seth Hayes. You will probably know him, or many of you, and so he would be delighted to answer any questions you may have. Inta has just adopted a new strategic plan that is the 2022 to 2025 strategic plan. We have three strategic directions. One is promoting and reinforcing the value of brands. I will share that a little bit more in detail in a minute. A second pillar is building a better society through brands, and a third pillar is about supporting and developing IP professionals that we all are. Something on the first strategic pillar, because that is where is the link with the bad faith trademark applications. We want to promote and reinforce the value of brands, and that also goes through international harmonization. That is very important for global brands. We are facing all kinds of barriers when law is not harmonized, and because trade is international, we also need as many harmonized laws as possible. And this particular topic on bad faith trademark applications is also very important in this particular setting. So I will not go through all the other elements that we include in this strategic pillar. There's a lot to do, of course, on all kinds of IP topics, but I wanted to mention this to see where it fits into our organization. It is a global issue, as mentioned. We see a rise in trademark filings overall, but we see especially an increase in the speed of business, and that is where we have this problem. And maybe to illustrate the speed of where things are going is the chart on the right of your screen. You can see that the number of years it took for each product to gain 50 million users has been going down rapidly. We see, for example, that in the airline industry that took 68 years, and now with all kinds of applications on smartphones, it can only take 19 days to reach the same number of users. So it is really going fast. It is really going global, and that poses all kinds of challenges with regard to trademark applications. There has been a very interesting study that I wanted to mention. You see here a slide with some extracts from this research report from the Council of Fashion Designers of America. It dates from 2018. And you can see actually that most victims of these practices, they are SMEs with revenue below $5 million US. So this is not an issue just for big companies. This is really relevant for all kinds of businesses. I think in terms of time also, because we are a bit behind schedule, I will not go through all these elements from the report. You have the link below, so you can see it in your materials if you want to dig into it. But it's very clear that from the surveys from this report that it is really a big issue in terms of market access, in terms of the cost of fighting this phenomenon. And yes, it is a widely felt issue. I think what is important to explain is the last bullet point of this slide. When we are confronted with bad faith trademark applications, it is a barrier to sourcing because it will be difficult to get products out of those markets when somebody else already has a trademark pending, and it's also difficult to get into that market for, of course, the same reason, because there is conflict about the brand. Unfortunately, it is not easy and quickly to remove those kind of obstacles. You will be aware of the time it takes to do opposition proceedings, cancellation proceedings. That is not done in a couple of hours or a couple of days, but much more. And so all that time, those businesses are suffering from the phenomenon. Again, I'll leave it at this for the report, but I do think it was important to mention. So INTA has already adopted a bad faith board resolution, and that the next presentation will be on this topic, on the particularities. I think it's very important to raise awareness among local brands and especially the SMEs about the issue. And we strongly invite all IP offices to come up with their own data, to do research on this, as this can help the discussion, and then it can be shared with other offices on a mutually shared basis. So that is what I wanted to share with you today. And so now we proceed directly, I think, with the presentation of Mr. Joel Blank. Thank you very much.
As mentioned, my name is Joel Blank, and I'm a member of the INTA Bad Faith Task Force. And I'm going to share a little bit of information today on that task force and what we've accomplished. I think it follows Ziger's presentation very well. So to get things started, the task force conducted a survey on bad faith, looking at 90 jurisdictions around the world, gathering data from those jurisdictions up through December of 2019 to determine the extent to which bad faith trademark filings created concerns and how those jurisdictions' IP offices dealt with the trademark registration process to prevent bad faith. You can read a summary of that survey on Inta's website, so I won't go into more details right now. But I want to say the main takeaways from that survey were really 4 points. And first, that bad faith is a serious issue that is needs to be dealt with across all of those jurisdictions. Jurisdictions typically do not provide the option to reject or refuse bad faith applications during the examination process. And this is something you heard Ziger just talk about. Or in cases where they do, it's a high evidentiary burden to overcome and be successful. Most countries, most jurisdictions do allow, however, bad faith to be challenged through either oppositions or cancellation proceedings, but not always both. And again, here at times with those proceedings, there's often high evidentiary thresholds that make it very difficult to meet that standard and to prove bad faith. After looking at these key takeaways, Inta concluded that they must take a formal position on bad faith trademarks, which resulted in a November 2020 statement by the Inta Board of Directors in the form of a board resolution. And that board resolution really contains 2 key elements. The first is a set of recommended best practices or minimum acceptable standards to be adopted by trademark offices. And second is an illustrative list and an explanation of how to conduct analysis of bad faith and standards or factors that can be considered. In other words, it really set up a framework for analysis for trademark offices and for courts on how to look at bad faith. Where are we going? Where's Inta going from here? Well, now that we've got this understanding in place in the board resolution, we're conducting advocacy efforts around the world to harmonize government policies, actions, and trademark systems by working with brand owners, associations, governments, international organizations, and others. Really, the purpose is to create this common understanding and a unified approach that prioritizes the needs of trademark owners and consumers in order to prevent bad faith activity, because without doing so, bad faith actors will continue to exploit the systems and the gaps in those systems. Where is bad faith happening? Well, the very simple answer is everywhere. You heard Ziger say this, there's a lot of activity in Asia, but we're seeing Inta seeing bad faith activity happen everywhere. And indeed, most of the respondents to this survey indicated that bad faith is an issue in their home jurisdiction, as well as others where they or their clients are engaged. Trademark offices as well from around the world have recognized that bad faith is an issue that they're facing. And indeed, many of the trademark offices are undertaking projects and initiatives to find new or strengthen existing mechanisms they have in place to prevent and provide expeditious challenges to bad faith trademark. So the conclusion is no jurisdiction is safe. Every jurisdiction has become a target for bad faith filers. And in fact, a very recent example, I think, is a good one to highlight, which is about 2 months old now, from the US Patent and Trademark Office. On December 10th of 2021, USPTO issued a sanctions order against respondents who in this case were foreign trademark agents who were representing clients before USPTO in contradiction to USPTO practice rules. And I won't go into the details of this, and you can find this actual order online, but essentially these foreign agents were circumventing the rules that required foreign trademark applicants before USPTO to have US qualified trademark lawyers representing them. And these foreign agents were falsifying information such as the domicile address of the applicants in order to suggest that these applicants were US based, again, in contradiction of the rules. So this is important because I think it shows two things. One, bad faith can take many different forms and can indeed be put forward by a combination of applicant and agent activity. And second, it can take place anywhere. Now, what's the harm of bad faith? Well, in the most simple terms, everyone is harmed by bad faith, but people often think bad faith is really something that harms the brand owner. But I think taking a step back, one needs to remember the purpose of the trademark system. Trademarks are in place to create a information exchange between a brand owner and its consumers in order to provide that consumer with information on the origin so they can make purchasing decisions based on quality, factors of the product or service, attributes, et cetera. And so when bad faith applicants muck up the system and create opportunity to confuse consumers, that's really truly harming consumers as well as brands, as well as governments. So bad faith really undermines trust in the entire system and undermines the dual purpose of that system. So what can be done? Well, I think you've heard some interesting solutions of what brands are doing, but it's important to remember that brands alone cannot solve this problem. And that's what the Inta board resolution really comes in. The board resolution was intended to provide a framework for brands and trademark offices to work effectively together in order to prevent and challenge and remove quickly bad faith trademarks. So I want to now turn to a little bit more information on the board resolution and what it contains and how it serves as that framework. And I'll walk through each of these here in turn. So first and foremost, the board resolution sets up minimum standards, the first of which is refusal. You heard Ziger talk about this. It's important that bad faith is an independent standalone ground for refusal at the examination stage. Trademark offices have to possess ex officio authority to take action and prevent the registration of an application made in bad faith in the first place. But this also needs to provide a mechanism for third parties to submit observations and information to facilitate the examiner's information pool. And this is extremely important because it can reduce the cost and the damage to brand owners and conserve resources both of the brands and of the IP office that's conducting this review by catching it before it's registered. And this will also deter bad faith applicants because they will now know that the likelihood of success of obtaining a registration is significantly decreased and whatever cost they incurred will be for naught. Now we see several examples of what this looks like in practice and what the rules, the laws, and the practice guides of IP offices might look like. And here you see they take typically one of two ways, either an affirmation that an application submitted in bad faith shall be rejected, or by sometimes requiring that an application be made in good faith and giving the trademark office the ability to reject or refuse the registration of an application that was made in contrary to good faith. Either one of those is an effective mechanism to have in place in how things can be worded to provide this type of authority. But any authority by the trademark office to refuse has to be backed up by an efficient system providing brand owners the ability to challenge. And that comes in two forms. There must be bad faith grounds for both opposition and invalidation. Now, these two are not interchangeable. To be effective, they must both exist. They must be efficient, both saving time and money, again, for the brand owners, but also for the IP office. One way this might work is to consolidate related proceedings by ensuring that related parties, maybe that are dealing with several different applications or registrations, but where there's common connections there, consolidate those into single proceedings in order to, again, increase the speed, but also save monetary resources for both the brand owners and the TMO. And these grounds need to be available for application both to the trademark office as well as to the courts, either directly or in the form of an efficient appeal. Now, again, this is important as a secondary system because trademark systems and trademark offices must recognize and emphasize that bad faith applications are indeed a serious problem. Opposition here, again, is an extremely important component of this in order to prevent the registration in the first place. once a registration becomes active, it's a much more difficult process to challenge that registration. But, and I think this brings back to something Ziegler's point had noted, you cannot put these challenges beyond reach, especially for SMEs. SMEs are significant targets of bad faith activity around the world, and SMEs don't have the resources that bigger brands and bigger trademark owners have. So you need to make sure that the efficiencies are there and the cost effectiveness are there in order to promote access by SMEs. And again here, what this might look like, here are two examples of two different laws that specify both opposition grounds are available and also removal or invalidation grounds are available. The key is to make sure that both of these systems are in place in the jurisdiction in order to provide as many mechanisms as possible to challenge. But that gets to another component that was raised earlier, which is the burden of proof. An effective system needs to be able to provide a mechanism to shift the burden of proof once a challenger has met a prima facie evidentiary threshold of bad faith. And then it shifts over to the applicant or the registrant to determine that their application was indeed done as a bona fide good faith application and registration, looking at whether they have a bona fide intent to use the mark or have engaged in bona fide or honest use of that mark since its registration. In other words, proving that indeed they have a justification, a good faith justification for coming up with that particular mark. And this is extremely important because it's often very difficult for the challenger to gather the full suite of evidence that might be necessary to overcome that information disparity, to prove the negative, to say that it is absolutely certain that this individual acted in bad faith. And this is really important as a means of evidence production, particularly in administrative proceedings, where the administrative agencies may not have the ability to compel the production of evidence by the party holding that evidence, in this case, the bad faith filer. Now, we often see this exemplified in case law in many jurisdictions. And here is a quote from a case that I think illustrates this concept very well, where you see the court had indicated that the initial burden rested with the challenger, but they were able to rebut through objective circumstances the presumption of good faith in that jurisdiction. And then the burden shifted over to the proprietor or the holder of the registration to provide plausible explanations. In other words, to illustrate a good faith reason why they applied for that particular mark. And this is an extremely helpful tool, again, to overcome that imbalance of information. The fourth recommendation in the board resolution is to have a best practice to maintain records. This means public searchable records that indicate when an individual has filed in bad faith. In other words, to identify bad faith filers, but searchability really is the key here. It needs to be a useful reference point in order to reduce the burdens on legitimate brand owners and the trademark office and courts. And to be effective, it needs to be focused both domestically and internationally. There was a great stat in Ziegler's presentation that talked about that bad faith activity isn't something that's limited to one jurisdiction or a few jurisdictions. And as our survey found, indeed, this is happening all over the world. And there's often connections between a bad faith application in jurisdiction A and jurisdictions B, C, D, E, F, G, et cetera. And so this is extremely important to prevent serial global bad faith activity. Now, what does this look like? Well, when we talk about records, people often think of a list, a blacklist of individuals who've previously been identified to have acted in bad faith. And this is a great tool, but this doesn't have to be the only tool. Having publicly accessible and searchable court and IPO decisions that identify and provide analysis on bad faith filings and can be used in providing evidence to examiners or to adjudicators or cited by those examiners and adjudicators is an extremely useful tool to have in place. And finally, to back all of this up, the fifth standard in the board resolution is punishments. And this is IP offices need to have the ability to impose fines, payments, or other sanctions against bad faith filers. This could be to reimburse rights holders for those significant legal expenses and costs that Ziegler talked about, or also subject bad faith applicants or their agents to administrative fines and have mechanisms to prevent them, again, the applicants or agents from submitting applications in the future. In other words, prohibiting them from future activity before the IP office. And this will go a long way in addressing that resource imbalance, recouping costs by TMOs and courts, and even some of those costs by the rights holders. And this will serve as a significant deterrent to bad faith activity because bad faith filers will know that they are on the hook for fines, money going to the other party, or indeed prohibitions from acting in the future. I want to show two examples of this. The first is a quote that comes from that US Patent and Trademark order I had talked about, which illustrates, as the excerpt here is, that the respondents were subject to two things. One is any application and submission that they were dealing with was terminated. And second, they were precluded from engaging in activity before USPTO in the future. That's a huge, significant outcome and deterrent that hopefully will have a bigger effect on others who might consider violating USPTO rules and acting in bad faith. The second is a citation to a rule in another jurisdiction that clearly indicates that the trademark office, if bad faith is found, has the ability to impose warnings and fines directly on the applicants. And there's a corresponding provision that applies the same principle to the agents supporting those applicants. Now, the second part of the board resolution talks about how to conduct an assessment of bad faith, how TMOs and courts can conduct a holistic review of the relevant factors to determine whether bad faith exists. And part of this is an illustrative list of factors, 10 factors that can help, but it's important to keep in mind one thing the board resolution emphasizes. These are helpful factors and should be used as a guide, but they're not an exhaustive list. You don't need to have any of these, in fact, in order to find bad faith, as bad faith is very case specific. The purpose of these factors and of some of the other things discussed in assessing bad faith in the board resolution is to ease the burden on the legitimate parties. That could be other things such as consolidating related proceedings or providing streamlined proceedings to deal with bad faith, shifting the burden, which we've talked a little bit about, but also introducing other ways to reduce procedural barriers and burdens, such as requirements to notarize, legalize, consularize evidence or translate evidence. Those things can go a long way in making the challenge mechanisms much more accessible. And finally, bad faith systems need to consider the well-known status of legitimate trademark, particularly in today's globally connected world where e-commerce is facilitating fast-paced commerce across borders, and trademarks and brands can become extremely well-known in a very short period of time. I mean, as you saw, in a matter of hours, you can have 50 million users recognition around the world, and bad faith actors will take advantage of that if the system isn't designed to protect those who are growing in notoriety. So I don't have time, unfortunately, to go through each of these, but as mentioned, the board resolution provides this list of 10 illustrative factors to consider when analyzing bad faith. And I would just recommend that you take a chance to review the board resolution where we talk about each of these factors and how a court can consider these, or a TMO can consider these. But again, we'll emphasize, while we listed 10 factors, none of these should be seen as a precondition or a requirement. You may have a case of bad faith where none of these factors are present, but it's still clear from other evidence and other factors that the applicant applied in bad faith. And so that kind of bringing that all together, then one thing brands can do and think about now is, how do I protect myself? Well, there are kind of 4 steps to that. First is to plan ahead. Think about your market strategy in the short, medium, and long term. What jurisdictions do you plan to be in, or might you be in? What mark or marks are going to be your primary driving marks, and what ones might develop soon as a primary mark? And what classes of goods and services are going to be your primary ones over those periods of time? And register. Take the time to register for those marks in those jurisdictions covering those classes of goods. Conduct monitoring. And Ziegler mentioned some of the things that his brand does to monitor what's going on all over the world, targeting your priority markets, but think again, priority in the short, medium, and long term. Then take that information and get engaged. Challenge the applications and registrations, whether that's by submitting observations, engaging in oppositions, or invalidations. And an important part of getting engaged is connect the dots. One of the statistics Ziegler had mentioned is that bad faith activity is oftentimes conducted by the same small group of people, or people who are connected to one another. They're engaging in 50 plus registrations, maybe concerning one brand's marks or multiple brands' marks. They're doing so not just in one jurisdiction, but they're doing so regionally and internationally. So establish those connections, help the TMO and the courts see that there is indeed bad faith activity, looking at all the evidence, connect those global dots. Now, it's important then, of course, to remember that brands can only do so much alone. And that, again, gets back to why the board resolution is so important. It's about creating efficiencies for brands and trademark offices to work together. And that brings me to my final point, noting that all of us who are on the program here today are advocates. We all have power, especially when we combine that power, to work together as brands its industry associations, and its government representatives to create the right partnership, the public-private partnership that's really necessary to develop the right systems in every jurisdiction and to utilize that system and to continue to evaluate and increase its efficiency, because the board resolution is a great foundation, but that foundation can only be useful and successful if it's adopted nearly universally and if trademark offices and brands put the effort and the time in to work together to make it a success. I apologize that was a very rushed presentation, and I would just follow up to say, if you have any questions at any point, our bad faith task force would love to have conversations, and you can reach out to us through your regional representative, through Seth, whose email address was mentioned earlier, and we'd be more than happy to have follow-up conversations and explain this in more detail. Thank you very much for your attention today and all of your support on bad faith issues overall.